Hello, everybody. Benjamin Gottlieb here with Gottlieb Law. I'm here today to talk to you about the difference between a quiet title action and a legal partition action under Arizona law. Now, a quiet title action occurs when an opposing party is asserting a competing interest in real property that is the subject of the action. Arizona law allows for the potential recovery of attorney's fees and costs to the claimant of a quiet title action if that claimant follows the pre-litigation statutory procedures that are attendant to that action. And that is where a letter is sent prior to the litigation beginning that provides the opposing party with the opportunity to deed back the disputed property, thereby avoiding the action. Quiet title actions generally arise in situations where there's a boundary dispute or where the claimant is trying to remove an invalid or a wrongful lien, or where there's been a breach of an agreement affecting title to real property, or whether someone is holding title to real property for the benefit of someone else. In a quiet title action, oftentimes a claimant will also record what's called a lis pendens, which will tie up the real property and prevent it from being sold during the pendency of that action. A legal partition action, on the other hand, occurs when there's two or more co-owners of real property, and one of the co-owners wants to sell the property to liquidate his or her interest. However, the parties cannot come to an agreement. Importantly, in a legal partition action, oftentimes what becomes in dispute are what are called contribution claims. The court, taking into effect equitable considerations, will determine whether mortgage payments were made disproportionately by one co-owner over the other, whether there were repairs made or upgrades and enhancement to the property value, and other considerations that might affect whether the court will fashion a contribution remedy for the benefit of one or more co-owners. It is important in a co-owner situation that if one party makes a down payment to the property, that the parties document this in writing so that later, if there's a dispute, it's very clear what the parties intended their rights and obligations to be with respect to that down payment. So that's what I wanted to talk to you guys about today, and I hope you guys have a great rest of your day.